Good morning. This is Rich Sierra, CEO of the Florida Small Business Legal Center. Welcome to Business SOS. This is episode 48 of Business SOS. We're very excited. We're getting close to that 50 mark. So I'm very excited, and thank you for listening to our show. I'd like you to participate with the show. If you have a question or legal question that you have that you'd like me to address in the show, please send it to me at richsierra.com. And if I select your question, I'll send you a free copy of my book, Business SOS, 8 Common Legal Mistakes Business Owners Make and How to Avoid Them, which is available on Amazon, Barnes & Noble. You can ask for your local bookstores. And in fact, this week, somebody watch one of our listeners watched with the video on buying a business and asked me for a free copy of my due diligence checklist, which I said, if you listen to the show and if you want a copy of that checklist that I use when you're considering buying a business, send me an email. He did, so he received a copy of that checklist. So I do appreciate you listening to the show as well. Anything that, of course, that we can help you with, we're here to help. Today, we're going to talk about why employment agreements are important in a small business. And this is something that is commonly overlooked. And prior to becoming an attorney, just to give you a little more background, I had the opportunity to work in human resources for about 7 years. I was a professional recruiter for 2 hospitals here in South Florida. So I have a little bit of HR background. So employment agreements are important, especially in small business. And a lot of small businesses do not use employment agreements. They do not use independent contractor agreements. And sometimes the relationship between the employer and the business owner, the employee and the business owner, is kind of loose. Sometimes they say, well, they're 1099 employees, which I said before that does not exist, or they're employees, but I kind of pay them cash, which you should not do. So I was saying before, employment agreements are important in small business. And if you're going to have an agreement, I recommend you don't do this yourself. Employment agreements have nuances, have a lot of details, as I will explain to you shortly in this episode. And in fact, my agreement has like 8 pages long, and that does not include exhibits. So this is not something that, you should go ahead and try to do yourself, simply because most likely things will be left out. You can have an agreement drafted by an attorney that you will be using, for future use. You don't have to have a new employment agreement every time a new employee comes in, unless it's a key employee or an executive. It's a different conversation altogether. But for the most part, you can have a good, solid employment agreement that you can use for all employees. And then you can go ahead and change the addendum. And I'll explain to you what I mean about that in reference to some things that are customized. You can do that to addendums without changing the whole body of the agreement. So why agreements are important? Number one, it produces clarity. In terms of what are your expectations from the employee will know exactly what is expected of him or her, and also you will also set the standard about what the employee is expecting from you with respect to that relationship, the work that employee is going to be doing for you. So it is important to have that. And now you have a different situation, especially since COVID, that employees also working remotely. So what is that going to look like in terms of the expectations that you will have from them working from home? Are they going to be checking in online? Are going to be clocking in through an online system when they begin, when they take their breaks, when they finish? That is important to have that in the agreement as well. When they're required to come to the office, that should be in the agreement as well. So one of the things that I want to do is basically go over some of the key points of the employment agreement and talk about some of the best practices. My employment agreement is what I like in agreements is clarity. I like to make them in plain English. I like to make sure that they are readable, that are understandable, that both parties understandable, and that the terms that you establish, the terms that you want in the agreement are clearly defined. No surprises. So anybody can read it, later say, yeah, this is very clear. So in terms of my employment agreement, one of the things that I start with is basically, that you intend to hire this employee for the position of blank, whether it's a, sales representative, customer service rep, general manager, whatever the position is. And it goes into when is the first date of employment. You want to know that right up from the beginning, when you're going to begin to start working. Whether you will have a probationary period. It is common for companies to say, we're going to give you a 90-day probationary period before you become permanent employee, quote unquote. And that's a practice that has been, I guess, perpetuated for a long time. In reality, in Florida, everyone, and you have an employment at will provision, meaning that an employee can be terminated at any time for any reason. Okay, with the exception of the protected, discrimination protected classes, but for the most part, an employer can terminate an employee for any reason in Florida, unless you have a contract that says you cannot be terminated. But it is important, it's you as the employer, to establish that you're going to have a beginning date, but also that the employee acknowledges and agrees that the employment with the company is not for a specified period. And the employee can be terminated anytime for any reason, with or without cause or notice by company or employee. So this is very clear. Although the expectation employee is going to be working for a period of time with you, but at the same time, it is clear that this relationship can end at any time, and that's something that you as the employer want to preserve that right. There have been discussions about, okay, we're going to give you an annual salary of, say, $50,000. That by saying that statement will imply that there is an expectation that the employee be working for the very minimum 1 year. So the way to kind of change that is that, the salary of the employee, it is based on an annual salary of $50,000. However, it will be paid by the hour at this rate. So it is an hourly rate based on this annual salary, but it's not construed that the employee will be working for an entire year for you. So that's the reason you need an attorney helping you drafting this contract to be very clear on what you want to offer. Okay? But this contract is a binding contract, and also when things go wrong, the contract will end up in litigation at some point, or the contract will be challenged. And at the end of the day, the contract will govern the relationship. That's why it's very important. The duties and position of the employee. So employee understand the objective of this position is to, provide, customer support, provide sales for the company. And then you have, what I like to see in my contract is to have an exhibit that actually has the entire job description, as an attachment to the contract. So that way it's very clear what the expectations are and what the obligations of the employee is in relation to what the employee is going to do for you. But also I like to include a clause that says that the employee understands the company reserves the right to change the employee's duties or responsibilities from time to time to meet the company's business needs and objectives. So to the degree, yes, you're going to have a job description, but it can change. You're still going to be paid the salary. You're still going to be paid the compensation, but that can change. So I like to have some flexibility with respect to having that job duties, because in a small business, pretty much everybody does a little bit of everything. There's not just one particular area that the person will do, the employee will do. The employee has to be flexible enough to do various things to help the business. Large companies, you have more people, you have more of a structure. Small business is different. The compensation is very important. To have it outlined. I like to utilize more of an hourly rate versus a annual rate. For the reasons that I said before, a hourly rate said this is the hourly rate. So that way it's very clear. It's based on 8-hour day. You have your breaks, you have your lunch. And So that way there's not a expectation that the employment is for a specific duration of time. And whether or not the position is full-time or part-time employees can get a contract as well. 20 hours, 10 hours, whatever the case may be, or full-time. Full-time is 40 hours a week. Remember, I'm not talking about permanent employee, and I really want you to discourage you from the use of the word permanent when referring to employees, okay? They're either full-time, part-time, or independent contractors. It is an at-will relationship. So, it's not something, and again, for whatever reason, the word permanent has been perpetuated after the 90-day probationary period. But I really want to discourage you from using you're going to be a permanent employee because it implies long-term employment. So I want you to be aware of that and keep that in mind. Whether or not the position is exempt or non-exempt, and that in and of itself is a whole different conversation, and maybe I'll bring a employment specialist at some point, or an HR specialist or an employment attorney to go over that with us. In a nutshell, it's whether or not the position qualifies for overtime pay, whether it's a exempt position. And then, and I'll give you an example of an exempt position. It's a general manager for a company that basically has supervisory capacity, and it does not get paid by the hour. But, it's an hourly rate. However, if the person works 1 hour, they get paid for the entire day. It's more of a salary type relationship. Whereas somebody working, for example, in the warehouse, moving boxes and basically organizing various packages and logistics, that's more likely to be an hourly type of rate and not an exempt position. So it'll be non-exempt. And I'm making these types of examples just really very general because the discussion about who's an exempt employee versus non-exempt is an episode in itself. So I just want to make you aware of that. And if you have any question about is this employee exempt and non-exempt, give us a call, give an employment attorney a call. So that way you have that definition very clear. For the purposes of this discussion today, I'm not going to tell you or define who's an exempt employee, who's not an exempt. But if you do not know that, make that phone call and ask, because that is very important. If you have a non-exempt employee pursuant to the Department of Labor classification, and you classify them as exempt, do not pay overtime, you could be liable for overtime wages. So it's that mistake you do not want to make. And if you have any doubts, make that phone call because it's very, very important. Okay? Whether or not you're going to be offering any company benefits, and at what time, at what time period. Say if the employee is eligible for health insurance, any type of dental insurance, life, whatever the case may be, 401k, at what time period the employee would be allowed to receive those benefits, whether it's 30 days, 60 days, 90 days, it depends. So if you're going to offer those benefits, you want to put it in the contract as well. Where is the place of work? Where the person's working out of the office, working from home, you want to actually list that there in the contract. I'd like to include a section on punctuality and attendance. When is the employee expected to work, show up to work? What is the policy on absenteeism? What is the policy if by any chance the employee is not going to show up to work? Within what time period the employee needs to call the supervisor or call you, the business owner, and tell you, listen, I'm not going to be able to show up to work. I'm not feeling well. My preference and what I have in my contract is basically should be within half an hour from the start of the workday. You should know within half an hour of the start of the workday whether somebody's not going to show up to work or somebody's going to be late, so you can make adjustments accordingly, especially if the employee is the one in charge of opening the office. So those are things that I'd like to include here. Another section that I like to include, and this comes up very frequently, and I just give you an example. Sometimes I get calls from my clients that, listen, an employee left the company and he took a lot of files and took our customer list and basically now started her own business. And what should I do? There are a lot of different things here. I'm just giving you a scenario. Okay. So I like to have a clause in my contracts that include confidentiality of proprietary information. And it's a long section. I'm not going to read it for you. It'll take it'll take a few minutes to do that. But the bottom line is this, every small business, especially small business, you have confidential information, you have know-how, you have formulas. If you're a restaurant, you have recipes, you have a customer list, you have email list, all that information that has taken time to develop over time, over the time of the business, that's proprietary. And sometimes we give access to our employees to that information because they need to be able to use it to work. Okay, but that information really belongs to you, belongs to the business. Okay, the employee doesn't have the right when the person leaves for whatever reason, whether they're terminated or because, they decided to go in a different direction, go somewhere else, to take that information with them in order to use it against you, to use it for their own personal benefit, because that information was not theirs in the first place. Theirs to have in the first place. So that's something that I like to include there in terms of what confidential information means. And it's a long list of items that I have. And to make it very clear that information belongs to an employer, belongs to you, and that information is not to be removed or utilized other than when their performance of their duties and its performance within the company for your business. Okay. So that goes into employee obligations. They're not going to disseminate, misappropriate, otherwise disclose any confidential information or trade secrets to anyone or use for employees' own or another's benefit. That includes, especially now with online media and everything is digitized, so it's very easy to have information be transferred to digital means. So that's important to have as well. You as the employer need to also create other safeguards, which is a different conversation, as to how to protect that information. So it's important to you to also at least protect that as well. And also include there, what are the consequences for failure to comply? If it is found that you find out that some information has been removed, has been utilized against your business, you basically get contacts from your customer, say, hey, so-and-so is contacting me about doing business with them. I thought it was working for you. What's going on? You find that out. So there are consequences to that gives you the right to seek a temporary injunction to prevent that employee from utilizing that information for their own personal benefit. Or if you find out that your competitor is using that information that the competitor would have never had, but for that employee providing it to this business, then you might have a tortious interference claims. That new business could actually have a problem, a legal issue. But the key here is to show those consequences and what would happen if that information is misappropriated, and have cases like that as well. Okay. You also want to mention that you're an equal opportunity employer. It's good to have it there. There's a list there of items that you want to include. The return of confidential material. It is important to tell the employee you're going to have material. You're going to have perhaps a laptop in the case they work from home. You're going to provide maybe a cell phone. You provide a lot of different tools for them to be able to do their work. So when the relationship ends, they agree to return that material upon a request, and that will be in the contract. And if they don't provide they don't return the material back to you, or the tools or the computer, okay, they give you the right to set off their last paycheck to pay for that. So if it's in the contract, it's okay, you can do it, but it has to be in the contract. It is also important that if you're going to provide any type of tools, like a cell phone or a laptop, that you can remotely are able to remove access to your information once the termination takes place. So everything, for the most part, everything is in the cloud now. So you should be able to go online, shut down the passwords, cancel them, shut down whatever accounts you need to do, need to basically close. So in order that when you receive the actual physical items, like a laptop or a mobile phone, really it's just simply a physical item, but it does not really change that. It will not give them any more access that they had before the termination. So you got to create some safeguards as well from your end and how to protect that information. If by any chance you are providing a company vehicle, then you want to have a policy, company vehicle policy as well. That is a different document that I do. I'm not going to go into that in great detail today or any detail, simply because in many small businesses, they don't provide company vehicles. Sometimes they do. So in a case like that, you want to ask your attorney, listen, I have a client that basically provides they service espresso machines. In fact, I might have them come in and do a podcast with us. So they provide company vehicles to employees. So in a case like that, you want to have company vehicle policy, and when that vehicle can be used, especially when they take it home over the weekends, when it can be used, how it can be used, where it can be used, where it can go, so that you want to make sure you have that in writing as well. Okay? Two important points I want to talk today as well is that I get calls from clients say, listen, I have a sales rep that left the company and he's contacting, my other sales reps to go to work for their competitor. Can they do that? My answer to that is that, do you have an employment agreement? That's my first question. And I say, no, I don't have one. Do you have a non-solicitation agreement? No, I don't have that as well. Do you have so in order for you to protect yourself from an employee contacting your employees, you need to have a non-solicitation of employees clause within your contract. We write that as well within the contract, said that, and you can have for a period of 1 year, for example, they're not to contact, in essence, push your employees. Contact your employees for the purposes of them working somewhere else. Okay, that would be a violation of the agreement. You have a legitimate business interest to do that. They want to go out socially, let's find out, nothing wrong with that. But in terms of the purposes of trying to get them to leave your company to work for someone else, you need to have that provision there, because in a small business, you have, a few employees, you have a handful of employees. So and someone leaves, it really creates an impact on that small business. So because then you got to hire someone else, you're going to have actually some work that is not going to get done. You got to hire someone else, then you got to train them. So this is an impact, it's a financial impact to the employer, to you as a business owner when somebody leaves. Another common question that I get is like, hey, listen, can I have a non-compete? And that in itself is another podcast. But for the purposes of this discussion, what I suggest, the answer is yes, you can have a non-compete. Has to be limited to what is called reasonable in scope and geographic limitation. So you got to have this, it has to be very narrow pursuant to the statute. What I suggest is basically a non-solicitation of customers. You're not going to be able to prevent somebody from, quote unquote, competing. I've seen non-compete agreements to say, you cannot sell this product anywhere in the United States. That's just not going to fly. Okay? That's not reasonable in scope. You're preventing somebody from making a living. And it is really used more as a deterrent to basically pursue that business. But what you can have is a non-solicitation of customers. You have a list of customers that you want to protect. If the employee wants to leave, you can have a clause there that they cannot contact your customers for a period of, say, for example, of 2 years. So that way, those customers are protected. And when somebody leaves, it's important for you also to and especially you have somebody that deals with customers in a regular basis, and that person has the possibility or the opportunity to perhaps be your competitor, to let the vendor, the customers know, hey, so-and-so is no longer working with us. From this point forward, you're going to work with us, work with this person, you transfer that. So it is important as well for you to take some proactive action. I have a section here, employees' duties following termination. It's important for them to cooperate. You have, in the case they need to sign any documents to complete the termination of the employment, what is called a further assurances clause. We'll have it there. And then also the obligation of the company when the person leaves. So obviously you want to, compensate them up to the time that they actually worked and provide the final paycheck. And there are other obligations regarding benefits, if they have health insurance, but that's something that your health insurance carrier will handle or your benefits manager will handle. And I'll just give you an example that if they have health insurance, for example, they leave, they receive what is called a COBRA letter, letting them know they can purchase health insurance at a specific rate once they leave for a period of time. And I'm not going to go into what time, that's a different topic altogether. But the point is there's some other obligations once a person leaves that you as the business owners have to comply. If you're not, well-versed in these topics, important to have a HR advisor. And there are some companies out there that provide remote HR for a very, very reasonable price. I've seen them as low as $99 a month they provide you like an HR consultant. Some payroll companies offer that. So my suggestion is you're growing. If you're not well-versed in HR obligations, consider using one of these companies, talking to them, see how they can help you, because a phone call with them, $100 a month will certainly save you a lot of headaches with respect to making sure that you're compliant with certain obligations. Okay. Another section, and last but not least, that I like to include here are the dispute resolution procedures. And if you heard me speak before, one of the things I talk about in the contract, and when I look at contracts, I immediately go into the term, how long has been the term, the obligations, and I go straight to dispute resolution, which is usually in the back. But that tells me, okay, this is the term of the agreement. These are the obligations. Obviously, look at the parties. And one of the parties obviously contacted me because it's a problem with the contract. But I want to find out, how is this contract, what is the agreement that they had when they enter into the contract to get resolved? So in sometimes there's nothing there. Something there's just basically agreement is silent as to how this matter can get resolved. Then I go into, okay, where was it signed, where the parties reside. So clearly, if there's nothing on the agreement that says we're going to resolve this way, then it automatically defaults to court, and it defaults into the state or the location where the contract was signed or where the defendant resides. So other than that, I like my contracts to have a dispute resolution process in order to solve disputes. And my preference, as I mentioned this before, is to consider mediation first. So I'll do a step process. I'll go first mediation if there's a dispute within the contract, and then arbitration. Again, this is more optional provisions. It's not a requirement. An employee and a small business owner say, you know what, I'd rather just not even have that and go straight to court if there's a dispute. There's an exception here. In the case you need to enforce any of the provisions of the violation of the confidentiality provision, the proprietary information, or the non-solicitation of employees, or the non-solicitation of customers. Clearly, in this particular case, the contracts that I draft will give you, the business owner, the ability to seek injunctive relief, seek an injunction. So there are many different ways to try to resolve the dispute. My preference, mediation is a lot less expensive than litigation. Sometimes you have to pursue litigation from the very beginning, but for the most part, a mediation is less expensive than litigation, so that's my preference. Other people might have different opinions. That's usually what I recommend, and it's up to the business owner to agree or disagree. And there's also the arbitration provision. And I think in the last episode that I had, I went to more of a deep dive as to the arbitration. What is arbitration? The benefits, pros and cons. So if you want to learn more about that, the last week's episode was on arbitration. And as you can see here, there are a lot of different areas in terms of developing an employment contract. It is not as simple as just downloading a form from the web. I do not recommend that. I mean, there's some good templates to work with and begin with, but your business is unique. Your needs are unique. So your contract needs to reflect your business. Your contract needs to reflect in the what you do. And also it is good for the employee to see the professionalism and how serious you take that relationship, that you're willing to invest time and money developing your contract, but also the employee will feel more reassured of the type of company that you are by having that contract, and the employee will understand his expectations by having that written contract. So it takes a little while to do, to prepare, but at the end of the day, it's worth it. If you have any questions about employment contracts, please feel free to send me an email at rich@richsierra.com. If you want to learn more about our legal services, my website is floridasmallbusinesslegalcenter.com. We're on Facebook at FSB Legal. If you would like to watch the video of this podcast, we're youtube.com/@RichardSierra. We're on X at Rich_Sierra. We're on Instagram at FSB Legal. If you want to give us a call, learn more about our services, if you have a legal issue that we can assist you with, our number is 866-842-5202. Remember that Business SOS, 8 Common Legal Mistakes business owners make and how to avoid them. It's available on Amazon, Barnes & Noble. You can ask for your local bookstores. If you like the podcast, please follow us. We're in Apple Podcasts, Spotify, wherever you enjoy your shows. I would appreciate a 5-star review, and you give us a write a review for us. That helps the algorithm promote the show through other business owners. Feel free to share it as well. Same thing with our YouTube channel. If you like it, please subscribe, and you'll get the new feeds as they come in every week. Until next week, this is Rich Sierra. Remember that my goal is to help you succeed.